My name is Michael Zeytoonian. I'm from Massachusetts. Biographically, I'll tell you that I grew up in Massachusetts. I went to law school. It was sort of a second or third career for me, went in the mid-30s. Wanted to start out in law school trying cases. So the first job I got was one that I was prosecuting child abuse cases in Westchester County, New York. And did that and truly enjoyed trying cases for the next 12 years for county government and then for the Attorney General's office in New York. Then I moved back to Massachusetts and partnered up with an old friend in a private law firm. And I began to take care of the litigation end of the firm. More and more developed a practice in employment law and business law, some negligence work. And as I got to know my clients, a lot of them were employers and businesses, small businesses, families, nonprofit organizations, realized that litigation was not good for them. It was expensive, it was cumbersome, time-consuming, damaging, took too much of their resources out of their businesses. At the same time, by fate or luck or divine intervention, I took some mediation training. Trained with the New Law Center. At the time, David Hoffman was at the New Law Center. And right after that, trained in collaborative law. And that was a movement that had begun in Massachusetts a couple of years before. And my area was not family. I don't do divorce work. So my thought and challenge was, how can I use these principles and this process and apply it to business and employment cases and make this a better way of resolving disputes for my clients and for my new clients. And that's basically how I got to that point. Took the training and began from then on looking at each case and the circumstances of the client, the business, the dispute, and looking at it from the perspective of what is the best dispute resolution method for that case. Sometimes it might be collaborative law, sometimes it might be mediation. Sometimes there's no legal issue and you just need to get a coach involved or a communications person. We've used case evaluators to help solve cases. I'm also trained as an ombuds person, and I thought that was just another skill set that I would use because oftentimes in my practice, which begins from prevention, my employer business clients, the first thing I want to do is keep them out of trouble, keep them from getting sued, keep them from claims. And so I work with them on preventive law, auditing their materials, how they do things, how they interview, training them in sexual harassment prevention, discrimination prevention. So to me, the spectrum of what I do as a lawyer begins with prevention and then proactively works through. And I'll try to use the least invasive and least taxing methods, and now look at litigation as the dispute resolution process of last resort, only when you have to. And when you think about it, the only times you really have to is if you need injunctive relief, that you need a court involved. If you're trying to create new case law, which most clients don't come to you and say, I want to create new case law, and if they just can't possibly work through a process that's non-adversarial. So I'm a partner in a firm, which I still continue to be. It's a firm that does several different areas of law, including litigation. But I realized that we need to take the dispute resolution that we do, the non-adversarial, interest-based dispute resolution approach, and put it in the spotlight, create some branding, and market it as a separate entity, not something that's buried within the other things that the firm does. So from a marketing branding perspective, as well as I see where my practice is going, and it's more and more going toward non-adversarial dispute resolution methods. So about a year ago, we started the Zeytoonian Center for Dispute Resolution. It is a separate LLC, and built a team. And it's a team of about 10 or 12 people. Some of them are professional experts, some of them are mediators, some of them are collaborative lawyers. All of our lawyers are trained collaboratively and in mediation, so they understand interest-based negotiation. And kind of like a Mission Impossible model where you look at the case and the circumstances and say, what does it need? And then put the team together to fit that need. So the center has been going on for a year, and we're making some great progress. And our brand, if you will, is starting with prevention and ending at the point where the client gives up control over the process and the decision making. So arbitration and litigation, which in my view are giving the decision making to someone else, that's not part of our center. If we look at a case and say that's what you need, we'll refer that to someone else. So we know where we want to live, and we want to live with what we call the sovereignty of the client. The client decides the process with the lawyer, works the process collaboratively, and decides the resolution. Civil, as you probably know, is a little slower to catch on than family. Family started in 1990. Everyone knows that story with Stu Webb. Civil, I think, has really begun to emerge over the last 5-6 years. And I remember in 2004, when the IACP's forum was in Boston, was the first organized meeting of civil practitioners, and said, how can we begin to organize and promote this idea? And shortly after that, the IACP, to its credit, funded and put together a weekend retreat of about 15 practitioners in Chicago. Pulled us up in a hotel room, hired Liz Ferris, who's just a brilliant facilitator, and work on what are our goals, what do we want to accomplish, what are the problems that we face, how do we achieve this, realizing that there are differences between civil cases and family cases, so a need to tweak the model to fit these cases. Realizing that we're going to be up against opposition eventually from the traditional law community that I think will come to see this as a replacing model. Because when you think about it, the non-adversarial models are very sustainable. If we talk in the language of today, sustainable model, sustainable business. They're quicker, they're cheaper, they're tailored, they're agile. They can be tailored to circumstances. They don't have the tremendous cost of discovery. They're not damaging. You look at the entrepreneurs of today. My son is 27. He owns a restaurant. If I ask him, hey, litigation will take 3-4 years and cost you this much money, that generation of entrepreneurs will look at you like you're crazy. Their life is not much faster. They need solutions faster, and they think in terms of solve my problem, not in terms of I want to beat the other side. So I think the legal community has to respond to that and be problem solvers, approach the dispute the way a business would approach a problem and say, I need to solve this, and move on.